At the age of 87, Ruth Bader Ginsburg, a scholar, attorney, judge, and justice, passed away on Friday. Ginsburg, who was born in the year Eleanor Roosevelt assumed the title of First Lady, witnessed, championed, and contributed to the institutionalization of the most arduous and underappreciated movement in contemporary American history, the emancipation of women. No other American, save Thurgood Marshall, has contributed so much to the cause of legal equality. To fully appreciate the impact of Ginsburg's 50-year-old influence on American politics, it is necessary to calculate the difference in time between then and now. At the time, there were less than 200 female judges in the country, and just 3 out of every 100 legal professionals were women. Richard Nixon had a conundrum in 1971 when he was preparing to name 2 Supreme Court justices. Nixon decided to hunt for someone who was, ideally, not a racist after yet another Southerner he had recruited was rejected for opposing desegregation. He thought of a woman to name. In a brief episode of hysteria, he told his assistants, "I'm not for women, honestly, in any job. Thank heavens there aren't any in the cabinet." He believed that women ought not to receive an education or ever be allowed to vote, even. However, he acknowledged the political imperative of appointing a woman to the bench given the strength of the women's rights movement, as it may potentially earn him a few but significant votes in the next election. He compared it to the Negro vote. That is an incredible thing. Subsequently, Chief Justice Warren Burger expressed his displeasure by telling Nixon he would step down if a woman was nominated. Finally, Nixon gave Lewis Powell a name. Ruth Bader Ginsburg was writing the brief for a case that was scheduled to be heard by the court, Reed v. Reed, while all these guys were hesitating. The ACLU employed Ginsburg. Reed v. Reed decided on November 22, 1971. Just weeks after Powell's confirmation hearings, shocked not only the political world from the start of the Republic, but also a century of American jurisprudence. Gender lines were not considered back-of-the-bus laws by legislators or judges before 1971, as Ginsburg would later write. Rather, it was claimed that these regulations elevated women. Thomas Jefferson had gone to great lengths to clarify that the framers of the Constitution did not include women in their conception of governance. If our state were a pure democracy, he said, women would still be excluded from their deliberations. They could not mix promiscuously in the public gatherings of men to prevent deprivation of morals and ambiguity of issues. It was intended that women be kept out for their safety. The argument had not been refuted by the early women's rights movement in the middle of the 19th century, and the court held that discrimination based on sex was neither expressly nor tacitly prohibited by the 14th Amendment, which was passed in 1868. The natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life, a Supreme Court justice said in a ruling on a case in which Myra Bradwell had sued the state of Illinois for denying her the right to practice law in 1873. That was a cage masquerading as a pedestal, as Ginsburg loved to remark. In the 1971 case of Reed v. Reed, the issue was an Idaho statute that required men to be given precedence over women while executing estates. After reviewing Ginsburg's brief, the court decided that discrimination based on gender was illegal under the 14th Amendment's equal protection guarantee for the first time. Burger, writing for the majority, employed language that Ginsburg had introduced. Whatever may be said about the positive values of avoiding intra-family controversy, the choice in this context may not lawfully be mandated solely on the basis of sex. To give a mandatory preference to members of either sex over members of the other, merely to accomplish the elimination of hearings on the merits, is to make the very kind of arbitrary legislative choice forbidden by the Equal Protection Clause of the 14th Amendment. A few years later, Chief Justice was at a loss for words when Ginsburg was arguing her own arguments before the court. "Mrs. Bader, Mrs. Ginsburg, Born in Brooklyn in 1933, Ruth Bader attended Cornell University, where she became friends with Martin Ginsburg. After being married, they applied to Harvard Law School, which had just started accepting female students. After raising their child and tending to Marty's cancer diagnosis, Ginsburg moved to New York City to complete her legal education at Columbia. Throughout her career, she encountered discrimination based on her sexual orientation. Despite finishing first in her class at Columbia, she was unable to secure a position as an attorney with a company in New York. Instead of giving up on prejudice, though, she made the decision to research it. In 1963, she started her teaching career at Rutgers. In 1969, when her second kid started preschool, she was promoted to full professor and started helping at the ACLU. She subsequently became the leader of the Women's Rights Project there. 2 months after the court's decision in Reed v. Reed was rendered in 1972, Ginsburg became the first female full professor at Columbia. She told the New York Times, "Time is the only thing that confines me." "I won't limit my actions in any way to appease them," Ginsburg argued 6 cases before the court while she was a professor at Columbia, winning 4 of them. According to Jeffrey Toobin's profile of Ginsburg, she learned an important lesson from the person who wrote her briefs. "My secretary said, 'I look at these pages and all I see is sex, sex, sex,' while I was working on all these cases involving sex discrimination. The judges are men, and once they learn that they won't be considering what you want them to consider," Ginsburg remarked. She made the decision to rebrand this kind of grievance as gender discrimination. Ginsburg once compared combating gender discrimination to knitting a sweater, a remark that may have been intended to demoralize her opponents. A constitutional amendment was what the actual sweater ought to have been. The Equal Rights Amendment was ratified by Congress in 1972, and Ginsburg fervently supported its passage, arguing that it pointed toward a legal system in which each person will be judged on individual merit and not on the basis of an unalterable trait of birth. She also disapproved of the court's reasoning in the 1973 case of Roe v. Wade, which was decided on privacy grounds rather than an equal rights one. As I noted in a 2018 column, Ginsburg turned down the ACLU's invitation to take on the Roe defense. During Ginsburg's confirmation hearings in 1980, an assistant in Strom Thurmond's office referred to her as a one-issue woman after Jimmy Carter nominated her to the D.C. Circuit Court. The only committee member to vote against her was Thurmond. Many feminists were so outraged by Ginsburg's stance on Roe that they refused to back her candidacy to the Supreme Court in 1993. "I think my approach is neither liberal nor conservative," she declared to the Joe Biden-led Senate Committee on the Judiciary. The notion that her nomination was not contentious is completely untrue, just as the notion that her thoughts following her confirmation were acerbic and scathing, akin to the Ginsburgs of her Saturday Night Live persona. Ginsburg supported moderation in speech, collegiality in debate, and the court as a whole. Not to mention, annoyingly, she was quite cautious. According to Toobin, she spent so much time considering what others said to her and deciding what to reply that her clerks came up with what they call the 2 Mississippi rule. After speaking, wait 2 beats before you say anything else. Her majority opinions were the most influential ones that she wrote, such as in U.S. v. Virginia, 1996, where the court determined that the Virginia Military Institute's denial of admission to women was a violation of the Equal Protection Clause. Ginsburg's viewpoint functioned as a historical lesson for both the public and her fellow justices. She remarked, "Women did not count among voters composing We the People through a century plus 3 decades and more. Women did not receive a constitutional right to vote until 1920. For 50 years afterward, it persisted as the dominant belief that the federal and state governments could deny women opportunities that were granted to men as long as there was a basis in reason for the discrimination." In 1971, for the first time in our nation's history, this court ruled in favor of a woman who complained that her state had denied her the equal protection of its laws, the speaker noted, marking the pivotal moment in the case of Reed versus Reed. Of course, Ginsburg's appointment to the bench marked the true turning point. The court had been quite moderate for the majority of Ginsburg's career. Modern conservatives did not start to appear on the court until Reagan nominated Antonin Scalia in the 1980s. Trump nominated Gorsuch and Kavanaugh, and George W. Bush appointed Justices Roberts and Alito during Ginsburg's term. Ginsburg was appointed the court's great dissenter when it changed, despite the fact that the post went completely against her personality. Ginsburg valued strong, sincere disagreements but detested narrow, biting viewpoints. The year before she was appointed to the court, in 1992, she denounced the immoderate tone of statements diverging from the positions of the court's majority in a speech titled Speaking in a Judicial Voice. She stated that the most effective dissent lays out differences without endangering collegiality or the public's faith and respect for the judiciary. She continued to stand by that even as she started to write an increasing number of independent opinions, a trend that started in Bush versus Gore, 2000, when she disagreed with the majority's choice to put a stop to the Florida recount. Furthermore, she stated, the court's own judgment will not allow the court's conclusion that a constitutionally adequate recount is impractical to be tested. The United States presidency shouldn't be decided by such an unproven prophecy. She permitted a rare lapse in decorum at the end of that opinion, writing, I dissent instead of respectfully I dissent, with a subdued rage.